We have our Attorney General here with us, Miss Liz Murrill. She's going to join us and give us an update on the litigation. I see Miss Murrill has a familiar face with her, so I'd like to welcome back to the House of Representatives former colleague, Representative Larry Freeman. Welcome, Mr. Freeman.
Thank you, Chairman. Thank you, members. I'm glad to be back, and sitting on this side of the table is a familiar place for myself as well. So thank you for having me.
If you wouldn't mind, everyone, introduce yourself for the committee, and then it's all yours.
Thank you, Mr. Chairman and members of the committee. It's great to be with you today as your new Attorney General. I'm Liz Murrill. Also have with me Tom Jones, who is the new Director of the Civil Division and has been involved in the litigation. And now Chief Deputy, almost Chief Deputy, assuming you confirm him, is Larry Freeman. So that'll be before you soon, too. I want to tell you that redistricting is hard. I'm not going to tell you this is easy. I think that you did the best job you could before. We've been in litigation. The last time redistricting in the 1990s, it was when the second majority-minority map was drawn, we ended up in litigation for a decade. So there is no guarantee that when you do this again, we won't still be in litigation, but we are in litigation now. The district court judge has conducted a fact-finding mission. That's what always happens, and made fact findings regarding the map. She issued an injunction. That injunction is not currently in effect for reasons that I can explain to you, but I think the bottom line is it is not currently in effect because the deadlines for the election that it enjoined are over. The courts, nevertheless, have told us to draw a new map. And they have indicated that we have a deadline to do that, or Judge Dick will draw the map for us. So you have an opportunity now to go back and draw the map again. And I think that it is not an easy task because the United States Supreme Court has not made it an easy task. They've given you some directives that seem to be to not give you a lot of clear lines for doing your job. I apologize on their behalf, but, we tried. I mean, I am defending that map. And so you won't hear me say that I believe that that map violated the redistricting criteria. I'm defending that map. But I will defend your new map if you draw a new map. So, it's an act of the legislature. My job is to defend the work of the legislature, and I will do that to the very best of my ability. I think that the difficulty is that in the Murrill v. Milligan case, which was the Alabama litigation that preceded ours, the Supreme Court issued an opinion, and it says that in a Section 2 disparate impact claim, which is different really from the work that you did. You did your work, you did it in good faith, but the plaintiffs will go to court and they will make a disparate impact claim, and that's what gets litigated. That has nothing to do with whether your intent was nefarious or not. Everyone can have had the right intent and followed the rules as they believed they were given to them and go to court, and the court can still say, under Section 2, there's a disparate impact. And because there's a disparate impact, you have to go back and do it again, or I will do it for you. And that is the short version of what Judge Dick has held and what has not been overturned by any court that we have brought it before since then. There's no definitive ruling on that case. It is still in litigation. If you pass a new act of the legislature, that will become the new law. So I'm happy to take some more questions. I think that what Murrill v. Milligan did, which is, I think, one question, is that it said you can't do this job once there's been some litigation over disparate impact. You can't really do the job without taking race into account. And so that's not illegal or improper to think about race when you're doing this. You can't really do it otherwise. I mean, that's the litigation is because someone has made a claim about the disparate impact. And so there's no way to not give some thought to what you're doing in that context, especially when it's preceded by some litigation and some fact-finding. But what the United States Supreme Court has said is that race can't predominate in the way that you draw your lines. So there have to be other reasons that would justify the map. And those are some, I thought Ms. Lowry did an excellent job of giving you what the broad parameters are. They aren't, they're not going to be it's not going to be easy because the Supreme Court hasn't made it real clear in terms of how you can meet strict scrutiny, Representative Marcel. I mean, it is a difficult task. And I think that some of the other directives that the court has given, like trying to keep geographical compactness, doing the best you can in terms of meeting all the other requirements, I mean, those are justifications that still apply. Maintaining communities of interest still apply. Balancing geographical, population still applies. So all of those things are, and then the totality of the circumstances is ultimately what the test is going to be that the courts apply. And so, I think that if that makes things even more confusing to you, I blame the courts. I mean, we have tried to get them to explain and give you more clear directions. It is ultimately your job. The Constitution makes this the job of the legislature to draw the maps, and then when we end up in litigation, it perverts that process because the way that the precedent is built, there's fact-finding that occurs from a judge that can override the very fact-finding that you've made and your legislative record, and that's just a product of precedent and how these cases have been litigated. It's not something I can change.
So let me just to kind of, I sat on this committee last 4 years, and we spent a long time working on the map that we ultimately ended up drawing. And with over 2/3 vote of the legislature, we upheld it over a veto override and whatnot. Went through, thought it was the most. 2/3 of us thought it was the most representative of the state of Louisiana. And even all the work we did, everything we've put into it, all the testimony we've heard, the deviation being what it is, close to zero, none of that matters with the federal judge in control. She has the ability to draw it without our input and can do what she was if we don't draw a map this week. Is that correct?
Well, she made fact findings of her own based on the evidence that was presented to her in court. And those fact findings are very difficult to overturn in the federal judicial system. I can talk to you about precedent, I can talk to you about terms of art in terms of appellate review, but at the end of the day, her fact finding becomes very difficult to overturn.
Okay, we have a couple of questions. Representative Thomas.
Thank you, Mr. Chair. Good morning. I think I heard you say that race is the predominant.
No, race cannot be the predominant factor in what you would draw. That would violate the Equal Protection Clause. So what you have to do is think about how to best draw the maps given the criteria that the Supreme Court has established without allowing race to be the predominant factor that drives the drawing of your lines. That's where the actual Equal Protection Clause violation will come in. So, you need to stay south of that. And then I think that, you're going to have a lot of other things that you have to think about when you draw these maps. Communities of interest is one of the most important ones. I think that's always been a driving feature of the maps or of the map drawing exercise. Core retention is what was discussed very heavily in Murrill v. Milligan, and I think core retention has now become, and I'm just going to tell you my personal opinion in trying to decipher Murrill v. Milligan. It was not easy. There are it's a very fractured opinion. But I think that core retention is the part that the court has given the least amount of attention to in this process now. That once you are trying to redraw the map, I think that core retention becomes a less important factor under Murrill v. Milligan.
Thank you.
Thank you, Representative Thomas. Representative Marcel.
Thank you. Let me start by congratulating you. I don't know if I should say congratulations or condolences. I'm not really sure. Congratulations.
Well, I asked for the job, so thank you.
Okay. Let me just go over a couple of things that you said, and so I can be clear in what you're telling us today. Number one, you said you're going to defend the map, Act 5, that they presented because that is your job to do so, correct?
Yes, I
And
am
so-
defending it now.
Correct, because that's what we hired you to do, defend us, right?
Right.
And if we pass another map, you'll defend that map as well.
That's correct.
The other thing that I heard you say was the judge has fact-finding matters. Can you kind of elaborate on what that means? That's based upon the testimony that was presented by the plaintiffs? Is that accurate? And the defense, obviously, she took both matters into consideration when she was doing her fact-finding.
She did. That doesn't mean I agree with them.
Okay. So
And I think that it's also a product of, this is part of what's frustrating, I think, for the legislature when it goes into litigation, because people can, like experts, for example, that are hired by the plaintiffs, no matter who they are, this could happen on the new map, right? Those experts can come and testify in court, and the judge can control that testimony. In our case, it happened in a very, very short turnaround in a preliminary injunction hearing, which is different from a trial on the merits. We've never had a trial on the merits. So, the court, the judge, whoever that judge may be, has an enormous amount of control over how much testimony is allowed and by whom and how much time we will have to do that. That was all very, very compressed when we litigated this right after the map was passed. We have not had any other fact-finding because we haven't had a trial on the merits. I have raised an objection to that because I think that you are entitled to have a trial on the merits, but the courts have not accepted those arguments at this point. They have told us to go back and draw the map, and they have given us a deadline. So, I am making the same arguments that I would make on the new map, but at the same time, the courts haven't given us a lot of safe harbor to go litigate the rest of this case. They've said, go do this.
So it is a fact that we do have 6 congressional districts in Louisiana. That is a fact, right? Is it also a fact that a third of the population is African American?
Approximately based on the data. I would also point out that 50% are women. I mean, there are other population, and gender and differences. Like, that's why Section 2 has never been, it is expressly stated in Section 2 of the Voting Rights Act that this is not an act of proportionate dividing. That is not permitted under Section 2. And so we can't just take that number and say, that's how we do this, because it's not that simple, and that's actually not permitted under the law.
So it's not permitted to say that we have 6 congressional districts, and of those 6 congressional districts, we talk about community interests, I think was one of them. So do you believe that all 5 of the other districts has all the community interests impacted in those, and African-American districts only should have 1?
Representative Marcel, the job of drawing the districts is yours.
I get it.
It's not mine, and
Right.
I am defending what I believe to have been a defensible map, and if you draw a new map, I will defend that map. Judge Dick has put us in a position, and the Fifth Circuit, the panel that reviewed that decision, and the whole court, when I asked them to go en banc, by declining to go en banc, have put us in a position of where we are today, where we need to draw a map. So I'm not here to tell you don't draw a map. I think we do have to draw a map, and I will defend that map.
And my final question, I heard my Representative Ballou talk about 2/3 of the legislature approving this map and voting for it. Bolu, I'm sorry. Bole. I just call you Bo, so I'm trying to get your real name.
We'll work on your Representative
Yes,
Marcel.
So Boye, I always call him Bo, but Boye, I heard him say that 2/3 of the legislature voted for this map, and he's absolutely accurate, because the majority of the legislature would support this map because it benefits them. We talk about our districts and our interests. What I did not hear him say is, because I sat at that table on the other side and presented a map, and none of the maps that we presented got out of this committee. So You know, it's unfair to say, okay, we passed it with the majority of the people because the majority of the people would support us not having an additional African American representation in another district. I get that, but it's not fair to say that those arguments weren't made to support that. I was one of those that made the argument to support an additional congressional map, and I think what we're hearing from Judge Kelly Dick
Shelley Dick.
Shelley Dick is that the map is not fair for the state of Louisiana, and what I agree with her on is that if we cannot, and we had an opportunity to draw this map ourselves, and we did not do it as it supports Section 2, in my opinion. I know you gave yours, but this is my opinion. So then we will allow her to draw that map if we can't do that. We can't draw a map right now, right? Is that accurate?
So what will happen if you do not draw a map is that she has set a trial date. It's very, very quick, and we will still be operating under the old map. So we will move forward then with a trial under the old map. There'll be a trial on the merits, the same record I think that was presented, and Tom can affirm or correct me if I'm wrong, but the record from the preliminary injunction hearing will all go into the court record, and we will look at whether we want to have additional testimony, and that trial will move forward. I don't expect Judge Dick to change her position. I think she will draw a map. And so you are getting the first opportunity to do that. I mean, in theory, we could have had a trial on the merits, and she could have said, I don't like the old map, or I don't like the map that you drew, and I'm going to redraw your map. But as a matter of law, you get the first shot at doing that.
No, we get a second shot at doing it. Thank you very much, though.
Thank you, Representative Marcel. Representative Farnham.
Thank you, Mr. Chairman. So a couple of things. So the parallel that the argument has been based on is the case in Alabama. Was that the one?
The Alabama case was litigated just, a few months ahead of ours, and so it went up to the Supreme Court before ours did, and so we've basically been our case was held in abeyance pending the outcome of that case.
And that was a 7-member district, right?
I believe so.
So they were trying to reach a second district in a 7-member state. So would you say, just in your opinion, is it harder to draw 2 of 6 than it is 2 of 7, just based on the compactness of the population of that state? Because wouldn't you say that every state has a different compactness? There's no 2 states that are identical, and maybe it's easier in one state that maybe the compactness is much more centrally located to reach that conclusion. Would you agree with that?
I would agree with you that every state is different, and that our population, how our population is spread out is different from every other state. Our population, I think, is relatively close to theirs. They'd probably have a little more population because they still have 7 districts. This isn't going to be easy. That's why I started out by saying I'm not here to tell you this is an easy job. You have a hard job. Our state is different. Every state is different from each other. And you have to do this based on the facts in our state. We have argued in our case that our state is different from Alabama with regard to, so that the fact findings can't be the same. We're not the same. Our history isn't the same. Our history of redistricting and redistricting litigation is not the same. And we brought those issues up, and here we are still. So
I know I spent the better part of 3 years going over this. I was on the committee last time and sat through numerous meetings on this across the period of the 3 years. Help me understand how the voting age population factors in when the black voting age population is lower than the total population in the state. How does that factor in?
You want to take that one?
Yeah, the judge,
Introduce yourself just quickly. Again.
You're on.
You're on.
The judge here in the Middle District has based her rulings on black.
If you don't mind, could you kind of speak into the mic a little bit? Or you can pull the mic to you, I believe, as well.
I'm sorry, my name is Tom Jones. I'm the director of the Civil Division in the Attorney General's office. The judge has principally based her ruling on black voting age population. That's what she's used as the primary criteria. Then the experts take that black voting age population, and they're very clever people, and they do very clever things with those numbers. They can persuade you on one side that the black voting age population should be analyzed this way, and the other experts can convince you of just the opposite the next day. But black voting age population has been the primary criteria for this judge's rulings.
You did say something earlier that race cannot be a determining factor of why you draw maps.
It can't be the predominant factor.
Isn't that the only reason we're here right now?
You know, we're here because of
But isn't
the
it the
courts
predominant
telling us
reason?
we have to be here. I mean, I think that's part of it. You know, I'm defending the map. I'm going to defend the new map. I want you to know, I mean, if you draw a new map, I'm defending that map.
I agree.
I'm not going to say that, you know, I mean, I have complaints about how this case was managed. I mean, not by our litigators, not, you know, I just think that we should have a trial on the merits. I have argued that in court. I have signed off on those pleadings. I still believe that that's true. The courts have told us to do this by a certain date, or it's going to be done for us.
I think the circular fashion of the 14th, the 15th Amendment, and this Section 2 of the Voting Rights Act is a circle. So it sends you in this race to chase your tail to try and accomplish what you're trying to accomplish, and each one contradicts the other one in the circle. So you end up in this never-ending loop of how do you accomplish what we're tasked to do here. We did look at a lot of maps, and you know, I personally think that the one we passed was a very legal, legitimate map, and we'll do the best we can with what we have. So appreciate your time today. Thank you, Mr. Chairman.
Thank you, Representative Farnham. Representative Carter.
Thank you, Mr. Chairman. Because this committee meeting is being viewed by people throughout the state, I think it's important that we be honest and put the whole picture why we're here, how we got here. It seems to be an impression that the old judge, Dix, trying to make us do something, even though we've done the right thing. Is it not true that the judge's job, her task, is to look at the law, first the law, the jurisprudence of reapportionment, and look at the statutes that's been passed in reapportionment, and other criteria that Congress has given us to see if we went about this the right way. She just didn't decide to say, I'm going to make them have another black district. That is not her job. And she did anything contrary to that, she certainly would have been reversed quite quickly. But what she did, she looked at the law, and there was a request made by motion to as to whether or not the plaintiff would succeed on this problem with disparity and what have you, if they went to trial. And she pretty much said, after studying the law and studying the facts and what action took place in this legislature, she decided it would probably succeed. So she asked the legislature to go back and try to do this over again the right way. And the legislature had that opportunity. We could get nothing done. Okay, so now the judge, it was stayed. The Attorney General's office, she expressed that she wanted another map, and a better map. She thought that's more legal, and so she asked the legislature to. There was a stay made by the Attorney General's office, and it was granted by the Fifth Circuit. And because of the Alabama case, and Alabama is different from. First of all, Alabama has 26% population African American. Louisiana 33%. Alabama has a larger overall population than Louisiana as well. That's why they have 7 congressmen. But you can't compare Alabama to Louisiana. But the law is pretty much it's the same. So based on that law, that judge says, well, y'all either going to do a map or I'm going to do a map. So he gave us a third time to do the map. Now, if you look at the analysis of what we done the last time, there was about 8 maps that were presented to this House and Government Affairs Committee. But there's only one map, the Speaker map, House Bill 1, that was even considered, seriously considered. I mean, there was some people came to the table and talk about these other maps, but it was asked by the Speaker then, the then Speaker, who was carrying the House Bill 1, did you look at Section 2 of the Voters' Right Act, and did you try to comply this map with Section 2? And the Speaker said no. Or did you look at the disparities that this map represents? Is this common sense? If you got a third of the population that is African American and 33%, did you look at those figures? You don't have to be the primary criteria, but you got to first look at whether or not it appears to be a fair map and compliant with the 14th Amendment, Section 2, and other Supreme Court jurisprudence. He said no. He said that he this is his map that he's presenting, and he didn't let the lawyers worry about all this other stuff. This is his map. So the record of the and I try to tell him this because I was asking questions on House Bill 1, like everybody else, why this map have a problem. And so the legislature knew the map had a problem, but they wouldn't listen to anybody else. So while I agree that your representation that race is not the sole factor, the factor is you got to have 6 divided equally, okay? And if it but Section 2 says if you got a group that is compact, and that vote certain voting patterns, that you should try to create a map that allow that group to represent a person of their choice. That's all it says. So I asked the Speaker, did you look at Section 2 and try to come up with a map that does that? He said, no, I didn't. So it's the Speaker's and the legislators' testimony in the record that caused them the problem they had when they went to the judge. Had they said, we look at Section 2, we tried to comply with Section 2, but we couldn't because the black population is so dispersed in the state, we could not get another district that was compact. They didn't say that. They didn't even try. So that's why the state is in the position it's in. Not because somebody's out there, some federal judge is out there trying to make Louisiana have another minority district. Now, however, I do agree that we need to have this opportunity, and it's wonderful to have this opportunity to try to create a map that will comply. Now, and I think that I applaud the governor because I think the governor wants to do the right thing. The new governor wants to do the right thing. He wants to have a map so we can do our own map and not a federal judge, and I support that. And so, but I don't want to give the impression that federal judge is just a bad monster, is trying to make us do something we shouldn't do. She has to comply with the law. Now, the Supreme Court has reviewed what the Attorney General Office presented up there on connection with the state, and they denied that. It's the United States Supreme Court saying you got to go back and do this map, not just Judge Dix. Okay? So we need to accept the fact that the map we had, based on the record, based on the testimony presented here in the legislature, based on the debate in the legislature, based on the law, it was not in compliance. Now, you can differ, people can differ because they don't like what the law says maybe, or they want to twist the law, but the fact of the matter is, it's not a sustainable map. This map is not sustainable that we have now. And so we have a chance to do that and not offend too many political notions at the same time. And so I just want to put that in the record that this is effort on the part of people, different political interests, to try to resolve an issue that has been defined by Supreme Court decision and by federal statute, and try to come up with a district that is acceptable. That's what we're trying to do. You know, and it doesn't mean that you're a bad person or you got a problem because you supported that last map. It's just that the record did not support. We didn't get enough input from other people that had concerns about it. We didn't allow people to have put their input in. Had we put 3 or 4 maps on the floor and explained why we put them on the floor, that might have been different. If we tried to do what the Supreme Courts over the years have told us to do, I happened to be on the legislature in 84 to 92 where we wrote a lot of the reapportionment maps. Okay, so this problem been around a long time. So we had oftentimes federal judges judges have to put us on the right track. So, okay, y'all doing good. Y'all working in the right direction, but y'all got to go back and do this over again. And that's what she did.
Thank you, Judge Carter. Vice Chairman Lyons.
Thank you, Mr. Chairman. Is it Ms. Murrill?
Murrill.
Murrill, I'm sorry. I have a question for you, but before I get into my question, I just wanted to note that as we talk about the Voting Rights Act and the premise of a lot of things that we've done, today is actually the holiday of Martin Luther King Day today, which his actual birthday is tomorrow. This is the observance of it today. So a lot of us question, as a federal holiday where everything was empty, what have you, is why we're here today. So I just want to remind everyone that one of the things that Martin Luther King did say was, there's never a wrong time to do the right thing. So we're here today, and we would not have any other, issue he would, that we're doing something that we'll be doing to correct where we at and so forth. But my question to you, ma'am, is you alluded to earlier that you want to have a preference to have a trial on the merits that you were requesting, asking for. So as a body here, as we're going to be going through this process, can you outline to us in any form necessary to get it across, what were some of those merits? Because I'm assuming when you say the trial on the merits, I mean that the merits of the decision that you may have had difference with, you had other merits that you wanted to talk about or maybe defend in the fact-finding portion that was not revealed.
So, Representative Lyons, when we went into this litigation, right after the legislature completed the map drawing process, we went into a very, very compressed hearing on a motion for a preliminary injunction. That is a different standard. It was very compressed. We did not have the length of time that we would ordinarily have for a full trial. I believe that, this is, you can blame it on the litigator in me, which is fine, but I believe that that the state, and I believe this under the new map that you pass, that we should be entitled to have a trial on the merits before we are forced to go in and change an act of the legislature. That is just a fundamental premise that I have about acts of the legislature and us being required by the courts to redo them. That as a practical matter, we did not have a lot of time, but we lost on that issue. We did, not just me, but the entire litigation team, including the lawyers who represented the legislature or the speaker and the president of the Senate at the time, and the Secretary of State. We asked to have a trial on the merits set before you were required to go into session, and we offered to do it quickly. So just to be clear, we were not trying to delay. We offered to do it in November. There was another trial set. We tried to do this quickly so that we could have a complete record upon which whatever the decision was. And we did not believe that Judge Dick would change her decision, but we still believe that the case should be before the courts on a complete record. It is not, because we never had a trial on the merits. The courts have told you to go back and draw a map, and they said we could have a trial on the merits, but we could do that after you draw a map. So just fundamentally, as a lawyer who represents you and defends the laws that you pass, your laws, if you have a law that you pass that you feel very strongly about, and the entire legislature has voted for it, even though some people may disagree with it, then I will defend your law. And I think that you are entitled, and the legislature is entitled to that defense. So that's the point that I was making. I don't think any of these cases should be tried and decided at the preliminary injunction stage. I think we are entitled to a trial on the merits. But at this point, the courts have told you, the federal courts have told me, and they have told you that we don't get that right now. You get to have this session right now, or Judge Dick is going to draw the map for you. So, I'm not here to say don't draw the map. I'm here to tell you, draw the map.
Okay. Thank you very much. Thank you, Mr. Chairman.
Thank you, Representative Lyons. Representative Gadberry.
Thank you, Mr. Chair. Ms. Murrill, if we draw a new map and Judge Dick decides she don't like that one,
Do we start all over again, or will she immediately draw a map? I don't think she's capable of drawing a map, number one. I just don't think she can do it. But
No federal
yeah.
judge does this without a demographer helping. I mean, she will ask for experts. She will ask for the maps to be submitted to her with expert testimony. And then she will decide, typically, she's probably going to decide which map to take, but she can tweak those lines. She can decide how to draw the map, how she wants to draw this map based on the input of the experts from both sides. She could appoint her own expert and have that expert assist her in the map drawing exercise. And remember, you've been through this before. A large part of this exercise is done through computer-generated maps. So, you put the numbers in, you start changing, you change the inputs, it spits out a new map. She's going to have to go through that same process that you did, and then we continue. So, I can't tell you that the plaintiffs will accept the map that you draw. She has established a timeline for the plaintiffs to amend their petition and challenge that map. And then we will go through the process again to determine whether or not that map is acceptable.
And for 4 years on this committee previously, I spent hours upon hours looking at this map, all the maps. And I looked at the plaintiff's maps, so to speak, that they presented before this group, and I didn't feel like any of those met the criteria. The overriding factor, I guess, was they had gerrymandered lines, which is against the Voting Rights Act. So I'm hearing that you said that the current map that's been rejected, I guess, by the judge, has it been to the U.S. Supreme Court? Because that's the next step.
It has not. The U.S. Supreme Court can decide whether to take a case or not take a case.
Right.
They have not taken our case. They stayed our case last summer while the Alabama case went forward and was litigated. They said, you just wait. They thought we had made a good case for a stay, and so they paused our case while they decided that one. But they did something, and this is kind of a term of art, but they granted cert in advance of judgment. That means they actually took our case, and then after they decided the Murrill case, the Alabama case, they just vacated their own grant and sent it back to us. So in a way, they took our case, and then they vacated their own decision to take our case, and they sent it back down to the Fifth Circuit and to Judge Dick. And so it's back in the hands of the district court judge who is supervised by the Fifth Circuit Court of Appeals. And so there has been some litigation between August and really through the summer since the Murrill case came out all the way through the time that the opinion was issued in November, I think, from the Fifth Circuit, where a panel of the Fifth Circuit said, you need to go draw a map by February 15th. So they actually suggested we should have done this before we legally really, or I think it was practically possible to even get it done. But, here you are. I think the governor heeded that call, that demand. We've had it reviewed by a number of judges. They have had nothing to say about our arguments. It's been radio silence. And so the only decision that remains in front of us right now is Judge Dick's. And so Judge Dick has set a timeline for us to have a trial. They did say we get to have a trial, but we don't get to have that trial until after you go through this exercise. And, she will do it for you.
And once we have that trial, we have the opportunity, if she still rejects the map, to appeal that?
If she rejects the new map?
Or the existing one, again?
Well, if you don't draw a map, then we will be back in front of her for the trial on the merits in very short order. and that case will continue. If you do draw a map, then the plaintiffs will have to decide whether they wish to challenge that map, whether they accept that map. And if they accept that map, then the whole case should be over.
Yep.
If they do not accept that map for whatever reason, then if they don't like it, I mean, it may be a perfectly acceptable map for some people. It may be a second majority minority map that some people like or that some people don't. So there's no guarantee that someone won't, that the plaintiffs will like the map. But if they could continue to challenge it, and now they will have to go and amend their pleadings, and we basically will start over because it is a new act of the legislature.
It's going to replace the existing map.
It will
Representative
replace the
Feb-
existing map.
Gadberry.
Well, I mean, along what Representative Farnham was saying earlier, you chase your tail on this thing.
Well, that's why I said
you
it's not
comply with
easy.
one part, and you check another part, and it doesn't meet the criteria, so you go back and rework your population or your districts, and that doesn't meet. So you're constantly going in a circle.
Look, I believe that the United States Supreme Court should give you better instructions. I do. I think that is the argument that we made last summer. And, you know, if you pass a map and somebody else challenges that map, I will make that argument again. I mean, I think that the courts have made this a difficult task for you. And so you are doing the best that you can now within the constraints of the rulings of the federal court. So, you know, it's not an easy task that you have, and I believe that the jurisprudence has made it confusing, and that the Supreme Court would be I mean, you know, in my opinion, that the Supreme Court ought to make its own jurisprudence clearer to those of you who have the job of drawing the maps. I think that's fair. The Constitution makes it clear that it is your job to draw the maps. I believe that it is not correct in terms of the balance of power between the state and federal government, between the Constitution, you know, view of how this should be happening, for the courts to create precedent that makes it impossible for you to follow. So I think they should give you better guidance. And you are here to do the best job that you can to try and draw the map, and I will defend the map. And then we will see what happens.
Yeah, members, look, we're not going to be able to litigate the litigation here in committee.
Well, you know, my problem is we had a year to draw this map, at least a year. Now we've got 8 days.
That's
Oh,
right.
you do? Oh, good.
That's because the judge gave you
Oh,
deadlines.
that's probably not going to work then. Thank you, Mr.
Thank you, Representative Gadberry. Representative Newell.
Thank you very much, Mr. Chairman. I don't have very many questions because I just don't have very many questions. To add what Judge Carter said, as far as ensuring that people are educated about this process, most of us who are attorneys or have some information or some kind of experience with a court system and process, we know that sometimes you do need a preliminary injunction when things need to happen quickly, particularly when there is going to be irreparable harm to the applicants. And in this case, the applicants were the minorities of this state who would have not been given the opportunity to vote for a candidate of choice in the elections that were quickly coming upon us at the end of the session, the first redistricting session. So those citizens, once again, did not have the opportunity to have a candidate of choice because this legislature could not come to an agreement. The process is not difficult. The rules, the guidelines, are not difficult if you want to understand the rules and guidelines that have been put before you. What makes it difficult is when we are choosing not to do what is right, not to do what is fair for all of the citizens that we represent. I have a lot of folks in my district that did not vote for me, but you know what I do? I still represent them in this body. some of us do not take upon that task. This is the first redistricting session that we have had. Well, 21 was the first redistricting session that the United States had after the expiration of Section 5 of the Voting Rights Act, which required all of our maps and every law that we made, and I'm saying we, states that have had a history of discrimination. Laws that we put in place before had to be reviewed by the United States Attorney General's office or by United States District Courts if they were challenged in court. This is why this has been such a foreign task, I guess, this second part, because we have taken on all of the onus, creating the maps and then going back and reviewing and redrawing and rewriting the maps, because this is the first time we've had to. Before, we would just throw something together and the United States would take over it. We don't have that luxury anymore. We don't have that opportunity of having someone else to say, all right, you messed this up, we about to do it. Thank God for Judge Dick. Just as it was stated that she doesn't have the knowledge or the know-how to write a map, Judge, I didn't see it. Clearly, we don't have it either. And we've been given every opportunity to learn, every opportunity to educate ourselves. But some of us take that information and, sir, what's your name again? I apologize.
Tom Jones.
Just as Mr. Jones said in his opening statement, you didn't turn me. Okay, thank you. Just as Mr. Jones said in his opening statement, you got one side that it's their job to confuse you and make you think this. The other side is their job to confuse you and make you think that. We are not here to confuse anybody. We should not try to confuse ourselves with trying not to do right. If we, as a body, task ourselves with representing the interests of all the citizens that we represent, whether they voted for us or not, whether we want them in our district or not, if we set ourselves to representing all, this is not going to be a difficult task. And the more we argue amongst ourselves, and the more we try to go and appease a national agenda that does not care for the state of Louisiana, the longer we're going to continue to have these fights and the more divided this state will be. I've never seen this state as divided as it is now. We used to have the divisions on just basic moral value things, but we always, as Louisiana, looked at family, looked at community, and tried to do what was right by our neighbors. I don't see that anymore. And that is what's making this process difficult. Judge also said that we had maps, and he pointed out the fact that we as large, and I think it was Rep. Marcel that said it, we did not have an opportunity to vote on all maps because all maps were not allowed to come out of this committee. There were options upon options to draw a second minority-majority congressional district. And they went all across this state to give minorities an opportunity to vote for their candidate of choice. They were not allowed to come out of this committee. We sat for a month, 6 hours at least a day, listening to the arguments and the makeup of each map and discussing voting age population versus population. So I understand why we're still having those questions, because we talked about it ad nauseum. But when you choose not to do right, that is when the process becomes difficult and it seems as though we can't make a headway. But I want to put it on the record that I didn't vote for none of the maps that came out. I didn't vote for any of the maps that Judge Dick had in front of her because they were not maps that were fair, and they were not maps that would take in consideration of all of the citizens of this great state that I call home, no matter how unfair or how unjust it is to me. We still need to look and make sure that Louisiana is a state that it used to be, considering all of her citizens. And thank you for your time, Mr. Chair. I don't have a question for anybody.
Yeah, let's try and keep this to questions for the Attorney General. We're going to have a time to talk about maps and all that, but if we'd like to try and stick to any kind of questions out of respect for the Attorney General's time. Representative Shammerhorn.
Thank you, Mr. Chairman. Good morning.
Good morning.
Welcome aboard.
Thank you.
My question is, if we do not present a different map, Judge Dick has threatened to draw her map. Is it not our
Promised, not threatened.
well, okay. Is it not our responsibility as legislators and protected by the Constitution that our map should be the one that is approved? Now, if she draws her own map, when she does, do we still have to approve? Would we have to approve her map? Or
No.
would it automatically go in force above what the Constitution says is our duties as representatives?
So let me kind of let me untangle that a little bit. If you draw a map now, that map will become an act of the legislature and it will supersede the prior act of the legislature. The old map goes away.
Okay.
If you do not draw a map, then the map that you drew before will be the map, and the plaintiffs will continue to litigate that. We will have a trial on the merits. The record from the preliminary injunction will be probably supplemented with some additional testimony. She will issue a new ruling, and she will issue a permanent injunction against the map. And then that will be litigated, which is my duty. And so I will continue to carry forth my duty to defend against the injunction. That's the process. If she draws the map herself, then someone could intervene and challenge that map. There are a number of different potential outcomes if she draws the map. We could accept that map. You don't get it back. You don't get another opportunity to approve her work. The only question is, can her work survive the scrutiny of the Fifth Circuit, who grades her papers, and potentially the United States Supreme Court, who grades their papers? And, I think what makes your job a little more complicated is that the prior, not the exact prior map, but the map before that had been pre-cleared. There had been litigation in the past over a majority-minority map that was declared unconstitutional. So, that's why I have never taken the position that our history is, or at least our recent history, is the same in redistricting as Alabama. And I believe that the courts need to make it more clear what your job is so that you can do it properly the first time, and we can all avoid the litigation side of this and continue to move forward with an act that, as I believe all your acts are presumed to be constitutional. That is, that's how I'll approach the next act that you issue. So I'm not picking and choosing. I mean, I think unless it's very clearly unconstitutional based on existing precedent, then my job is to defend the map. I mean, not just that map, any act of the legislature.
Thank you, ma'am.
Thank you, Representative Shammerhorn. Attorney General, that clears the board. Thank you for your time this morning. Mr. Freeman, Mr. Jones, thank you all for being here with us today. Look forward to working with you all in the future. And again, congratulations on your election.
Thank you very much. Thank you for having me, and good luck.
Thank
Thank
you,
you.
Mr. Chairman. Thank you, members.